Hello and welcome to Anulysis Law, and in this video we are going to see the evidentiary value of the narco-analysis test, brain mapping test, polygraph tests, etc. Now these tests are used as the lie detecting tests and also as the replacement to the third degree torture to which the accused are exposed to in order to extract the information from them. Secondly, it is also preferable to accept a scientific evidence as compared to the presumptions that are merely based on facts. So, obviously, when you are conducting narco-analysis tests or such kind of tests, which are itself the scientific tests, so law presumed that we should prefer such kinds of tests as compared to other kinds of presumptions which are merely based on the facts. But with time, it was also seen that these tests were misused, and not only misused, these were also going against the person's basic or fundamental rights. They were not only violating or they were not only violative of one's right to life, but they were also highly intruding into one's right to privacy, and they were also against the fundamental right of a person against self incrimination provided under Article 20, Clause 3. Even when these tests are conducted, police has to be in, so such statements have to be taken in the presence of a police. And we have already studied under section 161 of CRPC that any statement given to the police officer is inadmissible. So you can see that how these principles of laws were being violated, and because of these reasons, the court held in the landmark judgment of Selfie versus State of Karnataka that narco-analysis tests and such other kinds of tests are holding only weak evidentiary value, and they cannot be taken as a substantial piece of evidence. The court also differentiated between the testimonial acts and the physical evidence. Now, whatever evidence the police collects from the spot of crime, like saliva or sweat or fingernail clipping or blood or hair, whatever. So, in these cases, while police is collecting these things from the spot, they do not need to take the consent of that person. But in the cases of conducting such tests, one's consents have to be ensured. And if that person is not ready to give his consent, you cannot compel that person to undergo such tests, because that would be directly violative of Article 20, Clause 3, and also Article 21 of the Indian Constitution. So, therefore, it was also held that Section 53, 53 capital A, and 54 explanation A of the CRPC uses the terminologies and such other tests. They does not include the testimonial acts. So here the physical evidence is like saliva, blood, sputum, etc. On the other hand, testimonial acts are the tests like narco-analysis tests or such other kinds of tests, where that person's conduct is actually determined on the basis of what he is speaking under the influence of such, if he is being administered with the drugs, as in case of narco-analysis tests, then he is actually giving those answers in under the influence of that drugs, or on the basis of his external reactions, which are actually measured or mapped through the through the tests like polygraph tests or brain mapping tests, etc. So either you use the invasive techniques like narco-analysis tests or non-invasive techniques like polygraph test or brain mapping test or beep test or whatever. The thing is, when you are going against the consent of a person and you're compelling that person to give the evidence against himself, that means which is of incriminating nature, then you are actually violating his fundamental right provided under Article 20, Clause 3. So, therefore, the guidelines uh, uh, were including the following points. What were those things? The first thing was, as I had already told you, that these were the direct intrusion to the privacy of that person, and also violative of Section 161 of CRPC, where the evidence, whatever statements are given to the police during the course of investigation, are inadmissible. Secondly, when you have administered a person with certain drugs, you cannot anticipate questions because he is already under the influence of such drug, and he is not in a position to exercise his own choice to answer the questions. Thirdly, when he is under the influence of such a drug, he might be under extreme pain, and that may also impact overall not only his health but also impact his physiological responses. Therefore, the court also held that even if that test is being permitted, that has to be permitted voluntarily. That means only after ensuring that this person has given his consent, and not just consent, free consent. That means should not be under any influence, or should not be threatened, or under any promise, or where should not be under any misconception. Another important thing which was or another important guideline was that this consent should be recorded by the judicial magistrate, and this person upon whom the test is conducted, that person must have access to advocates. This is because of the reason that the advocate is in a better position to tell him the consequences of the statements which he might give during that process of undergoing that test. Now, the court also held that this test must be recorded by an independent agency. Independent agency means there should not be involvement of any interested party while such tests are conducted upon him, and the statements so obtained from such a person. Now, this person can be an accused or a victim or any other party to the case. So, this statement so extracted during the test, during the conducting of that test, that has to be of limited purpose only. That means they can be used only for the purpose of section 27 of the Indian Evidence Act. That means only in order to discover the fact of a case. Right now, what is the meaning of discovery of a fact? If a person is saying that while he's under such under the influence of such a drug, and he's undergoing such test, and if he says that this person has a weapon of murder, and he has actually he has concealed that weapon under some tree or at particular spot, and on the basis of that statement, if the police is able to discover that weapon from the very spot which was stated by that person, then in that case, so much of the statement can be admissible under section 27 of the Indian Evidence Act. I hope you could understand the evidentiary value of narco analysis by this small video. Thank you so much for watching this video.